Otherwise, the admin department will shout at me. So as I always say, this is recorded, and a link to the recording and the slides will be sent out to all the participants in due course, maybe over the next couple of days. So where we are today is capability dismissal. It's a breakfast briefing, usually the first Wednesday of every month, but obviously just after Christmas, didn't want to exacerbate your post-holiday blues by putting it on the first Wednesday. So here we are on the second Wednesday. Capability dismissal. The agenda of today is going to be a recap, just a quick whistle-stop tour of what a dismissal is again, what those potentially fair reasons for dismissal are under the Employment Rights Act 1996. Then we'll go into the various sub-facets of capability dismissal, namely poor performance and ill health as well. Also talk about qualifications too, because that can also be an issue, but less common than poor performance or ill health. Anything to do with illness, as you HR people or operational managers will know, always brings potential discrimination risks as well. And at the end of them, maybe 20, 25 minutes chat, we can have a Q&A session as well for anyone who wants to ask anything in a bit more detail. So, as I'm saying here, what is a dismissal? As it says on those 3 bullet points there, under the Employment Rights Act, Section 95, the contract is terminated by the employer. That's quite straightforward, and that's when the employer tells the employee, you are sacked, you are dismissed. The second one is one that people often forget about, and that's when a limited term contract expires without renewal, which probably in layman's terms is a fixed term contract coming to an end and it's not renewed. And the third one, and again, layman's terms, is constructive dismissal, and that's when the employee resigns due to the employer's conduct, where the employer behaves so badly that the employee can say that they are being constructively dismissed and they have been pushed out essentially by the organisation. Now, we're talking about capability and qualifications here, though that is one of the potentially fair reasons, but as you can see there are a number of other ones too. People will be more regularly aware of things like conduct, redundancy, statutory ban, SOSR, i.e. some other substantial reason, and we'll be talking about capability and qualifications. And these are only specifically activated under law if the person has over 2 years service. Anyone who is interested can find that out at section 98 of the ERA 96. Now, in that section there, capability is given these 2 sub-facets, these 2 definitions. So capability in relation to an employee means its capability assessed by reference to skill, aptitude, health, or any other physical or mental quality. And qualifications in relation to an employee means any degree, diploma, or other academic, technical, or professional qualification relevant to the position that he held. So what that means is, in practice, capability dismissals generally fall into 2 main groups, okay? The employee's poor performance or the employee's ill health. But as I say there, qualification dismissals still sometimes occasionally arise, okay? So let's talk through these, starting with poor performance. So, did the employer honestly believe on the reasonable grounds that the employee was incapable of performing their job? So, what are the reasonable behaviours expected of the employer? And we'll talk through those in a bit more detail as we go through here today. And did management fail or succeed in discharging its own responsibilities towards the employee? Because as with many things in the employer and the employee relationship, there are rights and obligations on both parties. So, what we're always trying to deal with here with any sort of dismissal, be it capability, dismissal, SOSR, conduct, you're trying to make the dismissal fair. So if you're ever taken to tribunal, you can argue that the dismissal was fair, or in the legal language, not unfair. So the key elements of the fairness are, number 1, was there a proper investigation? And again, people who have been involved in HR stuff before will know investigation is key in any sort of dismissal process. Was the employee made aware of the problem and given an opportunity to improve within a realistic timescale? Was the employee's progress reviewed during the review period? And has the employee been provided with the appropriate support and possibly training if required? Now, and if the employee is dismissed, is the employee offered a right of appeal against the decision to dismiss? And as ever, the decision to dismiss any appeal should be heard ideally by a more senior manager who's not been involved in the process thus far. So, for any sort of performance issues, you need to ascertain what the performance is that they should have been adhering to in the first place. So you set the required standard. Now, everyone will know that within a contract there are express terms, the things that are written down. This is what your job title is, this is your rate of pay is, this is where you work, things like that. But there's also implied terms of a contract, and one of them is an employee will perform the role to the minimum standard required. That is an implied term of the contract. So there could be some role-specific targets, like sales targets, widgets made per hour, but also soft skills as well. For example, how you interact with your customers and your colleagues, etc., things like that. And the expectations will vary on the seniority of the role as well. Somebody who's on the national minimum wage clearing the corner of the building will have different expectations to the chief executive officer, who has much higher obligations as well. For a senior role, there is a higher expectation of what is required. And importantly, the senior person should be capable of judging for themselves when something falls below that correct standard and be able to self-help and change what they're doing to meet that required standard. Now, when it comes to setting the required standard, some of the requirements of the job can actually be so obvious that the employee's attention does not need to be drawn to them. And the following quote is actually one of my favourite from employment law circles as well. You're about the nerd I am. So, a van driver does not need to be warned that he should not drink before he drives. The personnel director of a large company does not need to be told that he should not make racist or sexist comments about or to members of his staff. A pilot does not need to be warned that he should not crash the plane. That comes from the 1996 case of Burns versus Turboflex at the Employment Appeal Tribunal. And again, just to highlight that these are all live links, which will take you to the relevant bits of statute or the relevant cases if you're so interested. So, monitoring those required standards once you've set them. Probationary periods are very, very important and can be very important, certainly for new starts and for promoted roles as well. Appraisals and reviews. You should be regularly talking to your employees to tell them what they're doing well and tell them what they're not doing well as well, and areas to improve upon. And again, always document these reviews as well, not just the formal ones, but the on-the-job informal ones as well. Spoke to Billy about his skills on X, Y, and Z. Quick file note stuck in his HR file. Those make things much, much easier to progress further on down the line for performance management and for the defence of an employment tribunal claim later on. What these appraisals and reviews will allow you to show is if there is any additional training support that needs to be required or provided. And when you are going through these performance management routines, make sure you detail the duration and the level of the skill that you want them to adhere to, give them goals and timescales to deal with, essentially. And also deal with problems at an early stage. Addressing performance issues as soon as they arise is important from a legal perspective. It can also have a number of advantages for both employers and employees. For example, an employee is more likely to turn their performance around if concerns are highlighted at an early stage rather than if matters are left to fester. If offering training and support results in a positive outcome, this is less time consuming and costly than going through a performance management dismissal procedure and recruiting a replacement as well. And also being able to demonstrate that an employee has been given support and an opportunity to improve, that will most certainly improve the chances of defending any future employment tribunal claim, as I mentioned earlier on. And finally, as opposed to dismissal, consider some sort of formal warnings going through the disciplinary process, ideally following the ACAS guidelines as published in the ACAS Code of Practice on Disciplinary and Grievance Procedures. Okay, and again, we've got that link there, definitely.
That's me, Liz. I'll go over here because you're not getting
yeah, if I could just ask people to go on mute, perhaps, who are listening. It's got a wee bit of background noise in there, please. Okay, ideal, thanks very much. So, the dismissal process. If things haven't went correctly, despite your reasonable management and interventions, then again, you're looking to do a final dismissal meeting. Some procedural aspects, make sure that the employee has all the evidence beforehand. And that will be things like the goals that they were set, how they didn't hit them, and the management intervention that has been attempted, but unfortunately not been successful. Make sure that the employee has the right to be accompanied by a workplace colleague or a trade union rep at the meeting, and make sure the employee is given the full opportunity to speak to put her or his case forward as well. So it's not a fait accompli at the meeting too. The employer then considers the matter objectively and then makes a decision. And again, as I mentioned earlier on, if it is actually a dismissal decision, or even if it's in fact a disciplinary decision, Right of appeal, heard by a more senior manager who's not been involved in the process before. So, moving on from performance onto ill health. Similar processes as above, you still need to follow a fair process to get from A to B to move to an actual capability dismissal on this point. Now, for ill health matters, the employer should establish a true medical position as much as possible. And also consult with the employee before deciding whether to dismiss. Again, another case quote directly from one of the cases is, unless there are wholly exceptional circumstances before an employee is dismissed on the ground of ill health, it is necessary that he should be consulted and the matter discussed with him, and that in one way or another steps be taken by the employer to discover the true medical position. Now, depending on the ill health issue with the employee, that could be discussing with occupational health, could be writing to the employee's GP, or if it's a very specific illness, it could be writing to the employee's consultant or some other specialist medical practitioner. Now, the relevant factors here for a reasonable dismissal for ill health, again, they should be fairly straightforward and self-explanatory. So, you need to ascertain the nature of the employee's illness, ascertain the prospects of the employee returning to work and the likelihood of the recurrence of the illness as well. There's the need for the employer to have someone else doing that particular work too. If the person, for example, is in a very key role and hiring somebody is either difficult or very, very costly, that will be a factor as opposed to somebody who is in a relatively, inverted commas, basic role who can be filled easily with temp, for example. And what effect is the absence having on the rest of the workforce? Again, if it's causing a lot of extra work on the other remaining members of staff, that's a factor as well. Now, the extent to which the employee was made aware of the position, that goes back to one of the previous slides where I said you should be consulting and informing and having welfare meetings with the employee to find out the position, and so that nothing comes as a surprise to them when you do come to the final dismissal decision. And also the employee's length of service. It's not fully determinative, but it's something you should take into account. If somebody's been there for 40 odd years, then perhaps there is a greater duty for you to deal with issues than somebody who's been there for 25 months, for example, who's just got over the 2-year service length. But don't be fooled into thinking it's easier to select somebody who's got 25 months service than it is who's got 40 years service. It just means that you have to take a more nuanced approach depending on the facts of the circumstances of the particular case. So, long-term absence as well. As you'll know, ill health capability can be split into long-term absence or short-term recurring absence. So let's look at that first factor first. Factors to consider. As I mentioned earlier on, get the up-to-date medical position from occupational health, the GP, or the consultant. Make sure you're consulting with the employee, as I mentioned earlier on, so welfare meetings at regular intervals. And consider the availability of alternative employment. As I always say, when you're looking at any sort of dismissal option, tribunals are very keen for employers to investigate non-dismissal options as well. Can this person be given some sort of counselling, training, a final written warning, as opposed to just bang, always aiming for capability dismissal or conduct dismissal right from the off. And finally, a factor that's sometimes forgotten about is company sick pay. Right, dismissing an employee on sickness ground before they have exhausted their right to contractual sick pay will not necessarily be unfair. The continuing existence of contractual benefits is only one of the factors that a tribunal would consider when evaluating the overall fairness of the dismissal. So put another way, if someone has, for example, 6 months full pay, 6 months half pay, then there's not necessarily an absolute need to keep the person on for 12 months if they're clearly not ever going to be coming back, depending on the level of their illness. Now, this is a factor that trade union reps often bring up if you're looking to dismiss somebody on capability grounds when they still have some company sick pay left. Yes, it's a factor that has to be taken into account, but it's not absolutely determinative. Now, moving on to that second subfacet, short-term absences. The key elements here are review the pattern of the absences and the reasons for them. Warn the employee that they have required improvement in attendance and given them the chance to make representations in a similar manner to setting expectations and monitoring performance as mentioned above. So if somebody has an illness and they're off on a regular basis, you'll deal with that slightly differently from somebody who never declares an illness and is off every Monday after an Old Firm game. That's a different matter entirely, potentially. Now, consider whether the required improvement in attendance is needed If there is not, dismissal is likely to be reasonable. So if there's no improvement, then potentially dismissal may well be reasonable. Now, a final factor here, which again, some HR managers and trade union reps focus in on, perhaps unnecessarily, is just because the employee is fit at the time of dismissal does not necessarily make the dismissal unfair. An employment tribunal will look at the whole picture, the entire pattern of absence, going back the many weeks, months, if not years, when looking at the fairness of the dismissal. Now, however, I put in here but in capital letters, be wary of discrimination risks. Okay. A long-term or a short-term absences can be linked to disability, potentially depending on the nature of the illness that the person have. And even if the illness is not disclosed to the employer, employers can sometimes be found by employment tribunals to have what's known as constructive knowledge. They should have known about the disability, depending on what they see and hear from the employee. And again, that's another reason why up-to-date medical information is very, very important. So yeah, it's better to avoid discrimination at all costs, because there are some types of discrimination, namely direct discrimination, which cannot be justified. And that's, for example, where you find out somebody has a disability and you sack them for that particular disability. Whereas there are other types of discrimination that can be justified, things like discrimination arising out of disability or indirect discrimination. And that is where, for example, you dismiss somebody for the long-term absence, which is related to their illness. Now, you're not dismissing them because they have the illness, you're dismissing them because they have the impact of the disability, i.e. their long-term absence. Now, that can be justified so long as it's a proportionate means of achieving a legitimate aim. Now, as I always say during these breakfast briefings, if you have any issues on any specific cases, give us a call here at Scottish Engineering and we can talk you through what your obligations are. And as per that final bullet point, there is actually a positive obligation on the company to enact reasonable adjustments in the workplace. And a discussion on reasonable adjustments should form part of the absence management procedures. And now anyone who's phoned me during a capability dismissal or any sort of absence management process will always hear me rabbiting on saying, make sure you speak about reasonable adjustments, ask them about reasonable adjustments, and use that two-word phrase. Are there any reasonable adjustments that we can make in the workplace to try and facilitate your return to work? So, moving on to that third sub-facet, one that's not that common, it has to be said. So, qualification dismissal regarding capability. So, a wee quick recap. A dismissal will relate to the employee's qualifications if it relates to any degree, diploma, or other academic, technical, or professional qualification relevant to the employee's position. Now, common situations where this comes into play. So soon after recruitment, it emerges that the employee who's just been hired doesn't actually have the qualifications that they first said that she or he has. When the employee is employed on the understanding that they will obtain certain qualifications and they fail to do so, you're hired on this level, but you're expected to reach that level within X number of weeks or months. And this is where, number 3, is where the employer's requirements change. Now, this can be a difficult one because you've maybe had somebody in the organisation who's worked perhaps relatively successfully with X, Y, or Z qualifications. And because of the changing nature of the marketplace or the workforce, you need to have them have A, B, and C qualifications. And you put pressure on them. I mean, pressure on a positive way, give them support, funding, and direction on getting new qualifications, but they fail to do so. The tribunals have accepted that employers may reasonably require employees to obtain additional qualifications during employment, but it must be done reasonably, hence why the phrase it must reasonably require. And fourth bullet point, where the employee loses their qualifications during employment. And generally, most commonly, that's when somebody loses their driving license, invariably because of increasing points or even drink driving, something like that. Again, final bullet point, there has to be a fair process followed with the employee, and discussions with them and a search for suitable alternative vacancies is important, and especially for employees over 2 years service. For example, that first situation, when somebody's recruited but then found not to be qualified, that should be relatively straightforward due to the probable short length of service, unless, for example, it's a two-pay situation or an intra-company transfer or a promotion of the employee. In that case, the employee may well have more than 2 years service, and then a more involved process would be required. So that there was a whistle-stop tour of capability dismissal, covering off things like qualifications, performance, and ill health, with ill health being split into obviously short-term absence and long-term absence. I am happy to take any questions from you just now, either verbally or in the chat, or if you want to think about it afterwards and then email me, there are my contact details just now. Folks, over to yourself.
Kevin, I've got an employee with long service, probably over 20 years.
Yep.
Went off with COVID in October 2020, hasn't come back.
Yeah.
Exhausted sick pay, but she also has arthritis,
right,
which is getting worse.
Okay.
The medical certificates we've always got have always, they started off saying COVID, they're now just saying fatigue.
Saying what, sorry?
Fatigue.
Fatigue, right, okay.
Yeah. So we're kind of at the point now of kind of looking at capability, and we just kind of, I reckon that it should be pretty straightforward, but just wanted to check.
Most certainly, mate. And so have you got in contact with any medical professionals, for example, or occupational health or GP?
We've got an occupational health report probably from about 3-4 months ago, but didn't know whether or not is it worth getting another one just before we start the kind of conversation.
I would suspect so. Certainly when there are a number of different illnesses potentially at play here, if there is arthritis and then it was COVID, but now the medical certificates are now changing to fatigue, I would say that relying on something 3 or 4 months ago might just err into the unfairness aspect, because you want to be able to talk to the employee in the welfare meetings, the most recent ones, and certainly the capability dismissal about the up-to-date situation of ill health.
Sure.
So yes, I would most certainly say that up-to-date medical report would be in order here.
Super, thank you.
Okay. Any further questions?
Kevin, just one from myself. Sorry, my Wi-Fi dropped me at the end there and just came back in. You mentioned earlier on about, in relation to a discussion with the person, with the individual around themselves before a decision's made on a capability dismissal in relation to ill health. What about the position whereby the individual may not be able to either converse or process questions or information because of their health status, whether that be physical or mental? Is it appropriate then to perhaps use a third party who may be a next of kin or spouse?
Most certainly. The employment tribunal would look for you to investigate as many reasonable options as possible to try and get the employee's information from their head into you. So if that means using an appropriate adult, using a third party, emailing them questions in advance so that they have time to ascertain or take on board what you're going to be asking them, allowing them further time perhaps to get back in writing, most certainly. There is no absolute definite way of dealing with every situation. There are general levels of fairness and reasonableness, and if you are faced with a very unique barrier, for example, somebody's specific health issue that's precluding them from good communication, then do everything you can do reasonably to overcome that barrier as well. So as we say, bringing in somebody who can communicate on their behalf, or some other means where they've got time and the ability to look at the situation. As I always say to employers, especially for people who go over 2 years service, the final dismissal meeting, nothing in it should come as a surprise to an employee. They should know about the misconduct. They should know about the redundancy. They should know about the third party pressure, SOS are dismissing. They should know when it comes to a capability dismissal that the employer is considering dismissal because they've been offered this amount of time. So you're almost using the final capability meeting as just a recap of the situation and narrating through how you've got to this position, and then taking any final representations from them. And to answer your specific question again, if taking those final representations from the employee requires you to go the extra mile to give them further communication routes, then do so.
Okay, thank you.
Kevin, it's Debbie from Spirit Area Systems. We're quite far down a capability route with a long-serving employee with multiple illnesses. she's still in the receipt of company sick pay,
Right.
but her trade union rep and her have put together verbally at the minute, I've asked for it in writing, a list of some activities within the substantive role that they feel she can do, but essentially it breaks down the whole, it breaks down the whole role and intercepts areas where she can do admin at a desk. We don't feel it's reasonable. Would we be obligated to give it a trial period or anything like that?
You would, if it is, how can I say, if it's borderline reasonable, then potentially a trial of what is essentially a suggested reasonable adjustment from the employee, then that might be in order. But if it's so completely out of the park unreasonable, then
it's pretty disruptive.
You would need, well, what you have to do then is get your ducks in a row about the unreasonableness of their suggestion. Rather than just knocking it back out of hand, you go back to them with reasons, bullet points of why these suggestions from you are not going to work, employee and trade union rep, because of X, Y, and Z, A, B, and C.
Okay, so the only other thing that we have in our back pocket is a potential admin position, but we're trying to get an up-to-date OC health viewpoint because there's also some issues with her health round about sitting for a length of time. Would we be under any obligation to hold that recruitment process whilst the OC health information is being ascertained?
How long is it going to take to get occupational health? If it's going to be many months, then
no, it's probably weeks rather than months.
Weeks. Again, potentially not. I mean, how long has the admin position been open thus far?
The position's closed, but we were willing to let her apply, through the back door, if you like.
Yes.
It's an external vacancy. We've got interviews lined up this week, so we're right at the let's go forward place with it.
Again, it's very much these sort of questions are answered by how long is a piece of string, how reasonable is it for you to keep that position open, knowing or not knowing her current capability. Because if it's a relatively junior role and not having somebody in that role for a couple of weeks whilst you're getting occupational health, if that's not going to cause a major issue for the company, then that errs towards, waiting that little bit of time. However, if it's a fundamental role that you need somebody bum on seats straight away, then if it's waiting a number of weeks, if that would cause significant detriment to the organisation, then that takes it down to the other end of unreasonable adjustment as opposed to reasonable adjustment.
Okay, thanks very much.
Okay. Right, I'm happy to stay on for as long as necessary to answer questions. Don't have to finish at 8:30. Going once, going twice. Okay, folks, thanks very much for your time. As I say, I will get the PowerPoint slides and the link to the recording of this sent out in due course. So I'll bid you good morning and have a very good day. Cheers, folks.
Thank you.
Thank you.
Thank you, Kevin.
Bye-bye.
Thank you.
All right, mate, I'm just coming out.